advised, the Court of Appeals Division 1 is now in session.
Please be seated. Good afternoon, everyone. We are here for oral argument in case number 1CA CV160482, Go Services versus Avondale et al. I remind the parties that these proceedings are being audio and video recorded, so we would please ask counsel to identify yourself and your client at the beginning of your argument. Each side has 20 minutes. Appellant's counsel, you're responsible for watching the clock to reserve any portion of your time for rebuttal if you so desire. I will alert you that we have read the briefs. We've discussed this matter in conference today. You may proceed.
Thank you. To please the court, my name is Brian Hatch, and I represent the appellant plaintiff below, Go Services LLC. Go Services is a towing company, and I will refer to the appellant, my client, throughout as the towing company. And as a towing company, they perform a number of kinds of work. The work at issue here in this case, and which they do in the majority of cases, is police tows. That would be for a municipality, DPS, so forth. Those are done by public contract, and that's what we have at issue here today. It's a summary judgment case. It was decided by the court below on cross motions for summary judgment. Procedurally, there was a second motion for partial summary judgment, which was filed by the defendant. That partial motion for summary judgment dealt essentially with damages. Given the trial court's decision to grant summary judgment to the defendants, that's simply mooted. And so, if we get the remand that we are seeking, then that will come up at the trial court, obviously, damages phase, if you will, in this case.
Counsel, just so I understand your argument, you're not disputing the basic facts in this case, which are your client had a contract, your client was indicted on matters as it related to a previous company, towing company, and the defendant cities learned of that indictment in a newspaper article. And based on learning of that, terminated the contract. Is that the...
That is essentially correct. There is one...
So everything Judge McMurdy just said would be undisputed?
No. There is one dispute.
Okay.
The dispute lies in the characterization of the party. That is, Mr. Tom O'Brien, who is the stat agent and manager of the towing company, was charged and arrested. Not the company, not anybody else in the company. So the company, and the company is obviously who contracted with Avondale and Thompson. So, and that confusion permeates the trial court, permeates the defendant's...
Does it make a difference for your argument?
Sure.
And how so?
Well, because you basically have an employee of a towing company who was arrested, along with several others. In the actual reports that are in the record, the news reports claim 5 were arrested. There were actually closer to 13 that were arrested. All the office employees, basically, of what was SWAT towing, what was Auto City towing. So, and Mr. O'Brien was certainly among them. So that's not in dispute. And in fact, I don't think the material facts are in dispute. The issue is really what's material. And then when you go and look at what's material, well, then, a public entity such as the city, and I'll just, because they have the same argument and because the contract provisions are exactly the same in each case, I'll just refer to cities. All of the discretion that the cities have, and they do have discretion, no doubt about that. Public entities have discretion in these kinds of contracts, in public contracts. These happen to be rotational contracts, which means there are 4 or 5 actual contractors, and then the police agency.
But does it matter that these are public contracts? Let's say that this was a private contract with a mall, and it contained the exact same convenience clause as we have at issue here. Would it make any difference that there's not a public entity involved?
Well, yes, I suppose it would. I suppose the proof to show a breach would be somewhat different. I think it would center more around good faith and fair dealing. Because what you just posited, I mean, again.
Well, if you have an express term, though, I mean, the implied covenant is certainly there in both types of contracts, but if you have this express term, I'm having a hard time understanding the different standard you'd face with a public defendant versus a private one.
Certainly. Well, it's simply because there's a public trust issue. And the highest and best kind of contract that you get from a bid scenario is what controls the public entity's discretion, in this case, the cities. And so there's a whole body of law over how that discretion can be exercised.
I'm aware there's a whole body of law, and a lot of it's federal, but a lot of them deal with more nuance than we have here. I mean, this seems to be a fairly straightforward fact pattern. And so while there is a public trust issue involved, that's a factual matter. I'm not seeing how it impacts the legal standard.
Well, simply that, as in every case of summary judgment, what we have is undisputed facts and how those apply to the law. And the law surrounding the discretion to be exercised and how that discretion is to be exercised is specifically what we're here about. And again, we have, I know you've read the briefs and we've discussed it, so I'll just, the Brown case is very strong in terms of what is expected when the public, commission, council, contracting officer, city, what have you, exercises that discretion in that kind of contract and the determination for convenience. And that is that there has to be actual discretion exercised. I mean, again, the language in the Brown case is so strong. I mean, you have our Supreme Court just chiding the city council of Phoenix. It's an almost, how dare you do this without, and then they use some very colorful examples, as you see. And that speaks to me as an attorney. It says, look, there's a heightened standard. You can't just hide behind.
Although in Brown, the termination was being used, or the Supreme Court found it was being used for an ulterior purpose, right?
Well, actually, I think Brown was the award of a contract. So you might be thinking of Forest Guardians, perhaps. The same standard was articulated.
Right.
And Brown was cited that was a
Okay.
termination case.
But in any event, it seems most of the cases where the use of the clause is rejected involves some history where convenience isn't truly convenience. Convenience is there to cover up a flawed legal theory from another portion of the relationship. And that seems to be lacking here.
Well, I guess I'm not quite sure how to answer that. It is certainly true that neither of the cities terminated for cause, let's say, late to the toe, any of those sorts of things, and hidden behind the termination for convenience clause.
Well, you say hid behind, but, I mean, they put these convenience clauses specifically in contracts to allow them to terminate without doing for cause, right?
Correct.
All right. And in this case, there was an exercise of discretion, became aware of Mr. O'Brien's indictment, determined that given his relationship to Go Services, that in fact it was not conducive for them as a city to have a contract with him, or at least his company, and terminated him. I'm lacking, where's the lack of discretion in that?
Well, simply because they didn't exercise discretion except in avoid. There is nothing in the news reports that ties Mr. O'Brien to a particular cause of action, a particular claim, nothing.
Well,
And
if all we could rely on in public decision-making was the newspaper, I think we'd have bigger problems. But you mentioned yourself that there's a public trust issue in a public contract, and when one faces towing-related indictment, doesn't that create a problem of public trust that the municipal government really is responsible for ameliorating?
If that had actually happened, perhaps. But see, it all leads to the same conclusion. An investigation was not done.
Well, wait a minute. What investigation? Your client admitted that, in fact, he pled guilty. There was an indictment. There was nothing. I think your argument would be better if the news account was incorrect, but it wasn't. It was correct. So what investigation needed to be done?
Well, so again, let's go back to 2013 or the end of 2012. In December, the news articles come out and they say 5 people are arrested. They say there's this scheme. They say here's these 5 people. Nothing else. There's nothing else. There's nothing to tie Mr. O'Brien to a particular claim. Indictment is not issued. Mr. O'Brien has not pled guilty. This is a, how do you get there from here at the time? Because that's when they exercised their discretion, was January. Not in the middle of 2014, in the middle of litigation, when they finally got the indictment.
So, counsel, is your argument that they had to wait until the criminal matter was actually resolved?
No. No, my argument is they had to look at the criminal matter and if it impacted the contracts with the city at all.
Well, that sounds like for cause for me.
What?
That sounds like for cause for me.
No, that's actually what every case we've cited says about the exercise of proper discretion under a convenience clause. That's what Brown says, that's what Forest Guardian says, that's what all the federal cases say, including the sort of factually sexy case.
What facts would have revealed the connectivity that you're talking about with the contract?
What would they have discovered had they actually
No,
done an
no.
investigation?
What would they have had, under your view of the law, what facts would the cities have to investigate and identify and apparently gotten competent evidence, evidential matter to some level of what action or inaction, under your view, to exercise the convenience clause? What was required?
Well, what was required was, as in the Gulf Group case, where the court basically said, look, the claims, which in that case were, hey, they're sneaking around the base, they've got ties to Al-Qaeda, they've got all these things, those had to be substantiated. Those allegations had to be substantiated. And I think it's the same result here, as it was in Brown. Was Hertz or Avis better? Who had the lower price?
And they ultimately were substantiated, but you're saying, in essence, that by the plea, correct?
No. See, the plea was to an offense that was never charged. It was a damage.
Which is
Many pleas are.
And it was an amended, the indictment or information or complaint was amended, and the plea was guilty to the account as amended, which happens daily.
Yes, it does. Yes, it does.
How would the fact that it was amended affect the analysis here?
Well, that nobody was convicted of any of the charges that were actually brought in the original indictment.
So in your view, the case law that we will look at as we continue to work through this and have already would require that an alleged charge has to have been committed as alleged, not just a guilty plea, not just a criminal offense, not just a felony offense, but the actual charge. Now, would all of the charges in a multi-count indictment have to be shown under your view? Just one?
I don't think so at all. But see, the issue is that no investigation was done. Nothing. And had there been an investigation, then what would have been discovered, and this is in the briefs to a limited extent, was that the entire case was based on 10 pieces of paper that went to ADOT. In the middle of the page that says, has anyone contacted this company about title?
But to follow up on Judge McMurdy's point, though, isn't that argument, to the extent it's recognized by the law, far better with an acquittal than with a plea?
You know, I struggle with this, as I can see you are too. The idea that later in litigation, the defendants learned of things that they can point back to and say, well, look at that. There's a plea 2 years later after we didn't exercise our discretion correctly. Well, we were justified back then. That's what all that leads to. We're in summary judgment, and summary judgment is material facts. What were the material facts that the cities knew? It's only news reports, and their exercise of discretion couldn't have been based on anything else. Nothing that happened 2 years later. What was in front of them? Just as in the Gulf Group case, what was in front of them?
It seems you're arguing that the main problem here is a procedural one, right? That regardless of the substance of the conduct or the plea or anything like that, the fact that there was a procedural defect, in your view, before the discretion was exercised is enough. Is that a fair statement of your argument?
It is, if we acknowledge that statement is based on every case I cited.
Well, okay, but if we change the facts a little bit and we have an even more serious indictment, right, and say it's for first-degree murder and there's a plea to second-degree murder 2 years down the road, would the same procedural defect give you the same claim you have today?
Yes, I believe so. It is incumbent on the city to investigate, at least to some extent. Okay?
No matter what the facts actually show.
What's that?
No matter what the facts actually show in the end.
Well, how can you know unless you investigate? So yes, I mean.
Well, we know now.
But you see,
I mean,
again, that's justification later. And frankly, I don't think what we know now justifies the termination for convenience. Okay? A paperwork issue that ADOT doesn't care about in the basis for a 9-count impact. I mean,
would it justify the non-issuance of the contract? In other words, if a bidder said, I got to tell you, I've got some bad news here. My last company, I'm under indictment, or actually I've pled guilty to towing-related fraud charges. Would the municipality be within its rights to say, this is a bid we're not going to consider further?
That's a decent question. I suspect that, again, we're dealing with a completely hypothetical situation. So,
sure.
Yes, if there was a plea that involved the company's performance of the contract, but remember, Mr. O'Brien isn't driving trucks.
I understand.
What about the availability of equipment? The sort of things that concern a city, getting there on time, all those things. I mean, are they really concerned about publicity? I mean, so yes, there's certainly an edge to the exercise of that discretion, but I certainly agree that those sorts of things could be considered.
That could be reasonable grounds for insecurity.
Sure.
Like if a city was going to contract with a credit reporting agency and it said, I think we're going to pass on Equifax this year. That would be within the bounds of reason in your view.
I think it would be.
Okay.
But again, those are known facts. These haven't even been investigated. So, yeah.
I guess I'm still struggling with the notion that in a for convenience contract that you have a duty to investigate. When doesn't the duty to investigate suddenly turn that into a for cause issue?
I don't think so, and certainly Brown doesn't say that. Forest Guardians doesn't say that. None of the federal cases say that. So I don't think so. Could I possibly reserve my last 40 seconds?
Absolutely. Thank you, Mr. Hedge. Mr. Workman?
May it please the court, my name is Chaz Workins. I represent the Appalese, the cities of Avondale and Tolleson. As I see it, the resolution of this appeal involves two primary issues. The first of them is what standard does the court apply in judging the validity of a cancellation for convenience? And the second, whatever that standard is whether the city's concerns that were caused by the arrest of Go Services owner on felony criminal charges validate those cancellations. Now, with regard to the standard, I submit that it has not yet been clearly established by any case law in this state. There is no case that decides what the standard is in the context of a cancellation for convenience contract. Now, Arizona towing has been cited to you, but it does not decide the standard. DPS argued in that case that, and I think this was the case you were thinking of, Judge Swan, a minute ago. DPS argued in that case that the standard would be bad faith or abuse of discretion, which they claimed did not exist in that case. But they did not argue, and I think this is key, that they did not argue that the higher standard of the federal convenience cases would apply.
You know, there's all sorts of exciting nuance to public contracting law, especially in the federal realm, but I'm still not convinced on these facts that the public aspect of this contract makes any difference at all. Are you? Maybe you both agree, and I'm missing a point here, but it seems to me that the language of the contract is fairly clear, and whether it's a private or a public agency on these facts doesn't implicate a different standard.
Well, I understand that, but I think that there may be a difference because the city may be more concerned about the public perception than a private company.
But again, why is that a legal issue and not a factual issue? And absent state law telling us that there's a different standard, why are we assuming that there is one?
Well, I don't know that we have assumed that there is a different standard. I'm suggesting to you that the standard has not yet been decided by this court or any other court in Arizona.
So if we were to adopt the private standard.
Well, what is the private standard, though? Is it merely that the convenience cancellation is acceptable if it's other than for bad faith or as an abuse of discretion, or is it some heightened standard, some heightened level of that standard, which is what you seem to find in the federal cases?
Well, I understand you find that in the federal cases, but the federal cases deal with a different sovereign. And so while there may be an appealing analogy, I'm wondering why the actual written language of the contract isn't enough to guide our decision. Why do we feel compelled to look for a common law gloss where our common law contains none?
Well, going forward then, if you make no distinction between a private contract and a public contract.
That's perhaps a broader proposition than I'm suggesting. But on these facts, for this type of dispute, I'm asking the question. I'm not saying there's no relevance to having a public entity in a contract. I'm not trying to be radical here. I'm actually trying to just be careful with how we potentially expand the law beyond its current limits. So on these facts, with a contract that with these terms, I'm asking, would there be a legal impediment to our simply applying private standards, something akin to the covenant of good faith and fair dealing, or at least harmonious with it, and not looking for public contract doctrines that our law does not now contain?
Yet in the at least analogous, if not similar or even identical federal cases involving cancellations for convenience, you find the judicial expressions that the government is presumed to be acting in good faith, and so why not apply that same presumption to the cities of Tolleson and Avondale? Perhaps a private party isn't deserving of that in a contract with the same language, but the federal courts, at least the Federal Court of Claims most commonly, has found it to be true of federal agencies. And I think there's something to that, and I think that the distinction between the parties does make a difference in this case and can support this court's adoption of an even stricter standard for invalidating a cancellation for convenience.
Is there anything you can find in Arizona public policy that suggests that we should give the government preferential treatment over individuals? That we should assume that the government is acting in good faith when we don't assume that of individuals, or that the playing field should be tilted in favor of the government? I don't see that in our law. I know the federal cases say that, but I'm not seeing that here. And you know, we've been a state for more than 100 years now. I would think we would see something like that.
Your Honor, frankly, I had thought of that question before coming here today, and in fact, I thought it would be asked by you.
Wow. You were ahead of me.
That would be a first. But even crediting myself with that foresight, I cannot tell you, I do not have an answer. I do not have a case. I do not have an example drawn out of public policy that would justify the greater faith to be put in the government in Arizona and its contracts than applied to a citizen.
Counsel, do the briefs contain cases in Arizona or elsewhere construing convenience clauses between private parties?
Do they?
Yeah.
I don't think so, Your Honor. I think every one of the cases that both parties have cited involve governmental parties. And by the way, the Brown case is not a cancellation for convenience case. I think there's been some confusion here this afternoon about that. That was a bid award case, not the cancellation of a contract for convenience after the contract had been awarded.
A procurement challenge?
It was, yes.
Okay.
Okay. So, I think this court has before it an issue regarding what standard to apply, and that is where I first started to argue. And the choices seem to be whether you go with some basic sort of vanilla, bad faith, abuse of discretion standard, or if you go with a higher level of that indulges in some presumption that the government is dealing in good faith, and you couple that with the reluctance that's expressed in the case law to rebut that presumption, except when there is irrefutable proof of something like ill will, animus, oppressive conduct, conspiracy to get rid of someone, or some intent to injure. Those are all phrases borrowed from the federal cases.
You've described two paths that the court could go down analytically, and recognizing we're here on summary judgment, does the choice of those paths matter from your perspective?
I don't think it does when you then apply either standard to the facts of this case, and that is the second issue that I presented to you at the outset. I said whatever the standard, were the concerns of these cities sufficient to validate these cancellations? And I submit to you that whether you apply as I said, the basic standard or some more heightened standard, it doesn't matter in the end. The cities here were validly concerned about what they read or heard, saw in the news. They had entered into contracts with a company whose principal, not just principal, but I believe, according to this record, the only member, the sole member of the LLC, had just been arrested, along with others, for misconduct, criminal misconduct, in operating the same kind of company providing the same kind of services, but simply under another name.
To follow up, if I could, on Judge McMurdy's question, and he sort of described the facts that in many respects are undisputed, or at least almost undisputed. What if, in changing way that news is delivered, instead of a newspaper, this news was on Sam's blog? Does that give the city enough to say, no more, we're done?
Well, Your Honor, I think it might depend on what your blog or who your blog was quoting. Here, there were news reports. There were multiple news reports, and they are quoting a police department spokesperson who is talking about an extensive, complex, two-year, in-depth investigation.
Did those reports need to be right? Let's say that they were misquoted, and the city did the same thing. Would that be enough?
If they were enough to cause the city to have a legitimate, and it's subjective, honestly. You have to look at it from the city's point of view, and it doesn't matter whether the individual later turned out to be innocent or whether the news reports were wrong.
Well,
at that moment in time, we're in a contract with someone, and we had an expectation that we had contracted with a person of character, good character, and now we find that they have been arrested and charged with multiple criminal. And honestly, the newspaper accounts don't say felonies, but the police chief who made one of the affidavits in this case knows a felony from a misdemeanor.
So if it's an erroneous but caustic tweet, good enough?
No, we can't rely on the president's tweets here.
I'm not suggesting the president's. I'm suggesting some local Twitter account owner says, owner of Go Services arrested on felony charges, OMG. Is that good enough?
At that point, then there might be something to the argument that the city had some duty to investigate further.
But doesn't that go to Judge Thum's question, is you have to consider the source of the information, whether it be a tweet, a blog, the local newspaper, and what they're claiming. I mean, isn't it more than just there was a tweet, there were...
And what we have here is more than a tweet. What we have here are multiple news accounts from different sources, different publications, and they are, more than one of them, several of them, are quoting this person, a spokesperson from the Mesa Police Department, who is referring to this extensive investigation. And at that point, why does the city have to go out and retrace those steps and do its own investigation? What else would it find had it done its own investigation? It's reasonable for the city to rely upon those reports, multiple as they are and seemingly well-sourced as they are, in basing its concern regarding the contract relationship it finds itself in with this folk.
And so 2 months later, the newspaper comes out with a correction and says, we misidentified the arrested people. They were A, B, and C. We sincerely regret the error. At that point, is there an action?
No. After the city had already canceled? No.
Yeah, it turns out that the story was false, in my hypothetical.
Yes.
There's no answer, no action then?
No.
Is this because of the heightened standard that we presume?
No, it's not. No.
Okay.
No, because the city was not acting in bad faith in relying on those news reports. It was not abusing its discretion in then deciding to cancel for convenience.
But superficial reliance on a false and defamatory statement surely can't be good faith, right? And I'm talking now in my hypothetical. This is just an error by the newspaper. They just made a mistake.
You have been urged here this afternoon to look at a moment in time and not look back with the benefit of hindsight. Your hypothetical invokes hindsight. So if you look at that moment in time when these news reports are flooding the media and these two cities are asking themselves, what do we do? You know, at that point in time, it's not known that it's false. It's not known that he's innocent. It's not known that it's defamatory. None of your hypothetical.
Your observation is quite correct, and perhaps it's artificial to look at a moment in time. I think that's a fine observation. But if we look holistically at all the facts, then I guess my question to you is, does the development of the facts matter?
Well, then in development, we find out that there apparently was some fire beneath the smoke here, and there was a plea, albeit to a reduced charge. And we could also talk about the fact that he sends an email saying, I no longer can service your contract anyway.
Okay.
We can look at all sorts of things.
But so if we take the postmortem view, and the facts turn out to be helpful to you in this case, postmortem, I'm asking what would happen if we took that same view and the facts turned out to be unhelpful.
Well,
And again, I recognize it's a hypothetical.
and then looking at what the city knew, what did it know and when did it know it?
Mm-hmm.
And at that, and a moment in time is too compressed. I would rather use a period of time between news reports and the decision to cancel. During that period of time, did the city, based on that information, abuse its discretion or act in bad faith?
There wasn't anything in this case, though, from the time the news reports came out until the cities terminated the contract. There wasn't not additional information they learned. So we are still talking about a narrow.
We are indeed. We are indeed. And I think what the argument about the city's duty to make an investigation, which I submit to you would be superfluous, because they're not going to go out and, as I said, retrace the steps of the cops over a 2-year period of time to make sure that the cops were right. The big flaw in their argument is that if they have not shown that had the city conducted any investigation, they would have learned anything that would have caused them to conclude that there is no cause for concern in being in a contract relationship with this individual. That is just absent from this record. So, to me, that is the key to defeating this argument about an investigation, because had it been done, what would have been found? They haven't shown what would have been found. There's just this allusion to, you would have found that there was some paperwork problem. Well, I think that's a gross understatement of what was behind these multiple charges, dealing in stolen property and engaging in fraudulent schemes and so forth. It sounds like a lot more than just checking the wrong box on some ADOT form.
Let me take you back to the legal standard for one moment. The federal standard has evolved with an eye toward the United States government, which is a large, bulky, and procedure-laden, some might say bureaucratic organization, but it is one large, more carefully managed behemoth. Do you think the same considerations and the same judicial temptation, perhaps, to engage in a presumption of good faith should apply to a municipality of 300 people? Because if you're going to say the government is presumed to act in good faith, that's a very different thing when you're evaluating, one of the largest, possibly the largest government on earth, and a city council of 5 of 300 community members.
In principle, why is it any different?
Well, I'm asking. I don't know why judges create these presumptions at all, but I'm trying to explore that to see whether maybe the fundamental nature of the different sovereigns might have contributed to the development of that standard.
I think perhaps the presumption springs from this ideal that our governments are going to, at whatever level, of whatever size, are going to always act honorably, and until proven otherwise. So, That's what that's my answer to you this afternoon.
I appreciate that.
In 3 seconds, I have to sit down.
Thank
If
you.
you have any further questions, I'd be happy to take them.
No, thank you very much, Mr. Worker. Mr. Hatch.
Thank you, Judge. Well, I think I'll start in with what we just talked about. I think the presumptions that we were just speaking of spring from the historical background of requirements contracts pursuant to material for World War II. That's where the federal standards comes from. That, in doing that sort of requirements contract, that's where the termination for convenience became an issue. And the courts, the development of that area of law had to do with the idea that it would be an illusory contract, which is what general civil law, obviously we don't know about that. And that's precisely what these standards are getting at. Otherwise, when you have a termination for convenience clause that has no parameters around the exercise of discretion for convenience, you've got an illusory contract. You know, you're basically at, we'll perform if we damn well feel like it, is, you know, how I heard in law school. And so that's our issue. Here, you know, Arizona law picks up on that. And, you know, in the case of public contracts, has those standards. It is an abuse of discretion standard. Discretion can't be exercised in a vacuum. It must be pursuant to some investigation. In our case, the investigation isn't of the criminal charge. Nobody's ever said that. The investigation is of the impact of the arrest on performance of the contracts. Does Mr. O'Brien's arrest have any impact on the performance of the contract? Was there public perception? Who knows? Nobody ever looked. Was there anything that would keep the manager of that LLC in jail and thus not able to direct? I mean, none of that. Nothing. So that's really the issue. The investigation has nothing to do with substantiating the claims. It has to do with the impact on the contract.
All right, thank you very much, Mr. Hatch. The matter is deemed submitted. We'll issue a decision in due course.